where he and his administration has multiplied exponentially the number of documents, records, that were classified as secret. Vice President Cheney's office even claimed to be constitutionally exempt from reporting to the National Archives, the way all government departments are required to report, the number, he wouldn't even release to the National Archives, the number of documents that his office branded as top secret. He also, you probably remember in the early days of the Bush administration, had secret meetings with oil company executives to try to hammer out the administration's energy policy. And he refused to disclose the names of any of those executives that he met with. And then the government successfully beat the environmentalists, the Sierra Club's lawsuit under the Freedom of Information Act in an attempt to identify who those people were. We still don't know. The Obama administration is definitely less secretive than the Bush administration was, but this administration has been aggressively pursuing leakers. It has brought 5, or possibly a 6th, I think they just indicted a 6th a couple of weeks ago, 6 leakers, whistleblowers, brought criminal cases against the government employees or former government employees who allegedly leaked classified material. That's more than have been brought by all previous administrations combined, criminal prosecutions against leakers. And then the Obama administration successfully got Congress to exempt from the Freedom of Information Act 2,000 pictures of Abu Ghraib type torture. The Congress, at the administration's request, protected those pictures from disclosure under the Freedom of Information Act. The administration also refused, of course, to release pictures of the dead Osama bin Laden or of Anwar al-Awlaki, who the cleric in Yemen who inspired a bunch of terrorist activity, who was assassinated in a drone attack in Yemen not so long ago. You're not going to see any pictures of those. The government always has, and some of the reasons are good ones, always has plausible reasons for keeping secrets and restricting speech, and argues that competing values, important ones like national security, justify restrictions on speech. I sketch these highlights of the history of government secrecy just to remind you that government transparency is not constitutionally mandated, and to suggest that this lack of transparency opened the door to WikiLeaks. The lack of a constitutionally recognized people's right to know came home to me in the case involving the Santa Rita jail at Houchins versus K3D, and it involved whether there's a right of access by the press and the public to a county jail. And the court decided in that case that there's no such thing as a First Amendment right of access by either press or public, not just to a jail, but to any government facility or any government information. So that's the environment when WikiLeaks came on the scene, a constitutional tolerance for secrecy, and a long history of it. To the extent that WikiLeaks informs us citizens what the government is doing in our name, it partially repairs this flaw in our constitutional protection. If we were better guaranteed access to government information, greater transparency, there would be less point to WikiLeaks. The second gap in constitutional protection that I think encouraged the WikiLeaks phenomenon has to do with the reporter's ability to protect confidential sources. And it may not be a coincidence that WikiLeaks came on the scene not after the Supreme, just about the same time, right after. The Supreme Court refused to hear the case of Judith Miller, who had been a reporter on a national security Middle East beat for the New York Times. And in 2005, you may remember, she was sent to jail for refusal to disclose to a grand jury who her confidential sources were, information given to her by a confidential source, whom we now know to be Louis Scooter Libby, who was Vice President Cheney's chief of staff, who had a relationship, a purely professional relationship with Judith Miller, and was her source, but she wasn't going to disclose it. Miller had been subpoenaed by a grand jury investigating who was the source of the leak of Valerie Plame's name and identity. Valerie Plame was an undercover CIA agent, subject of a movie now. I forgot the name of it. Remember the name of that movie? It was a pretty good movie. After her husband, who was a former diplomat, had debunked the Bush administration's claim that Saddam Hussein was seeking nuclear material in Africa, and the administration was highly upset that Plame's husband he wrote an op-ed piece in the New York Times saying he was delegated to go to Africa and find out, get to the bottom of this, and he found nothing, that the administration's claim that Saddam was seeking nuclear material in Africa was bogus, and the administration was highly upset, and so one thing led to another. There was an investigation of who had leaked the name of Valerie Plame to embarrass her husband, and they couldn't figure out whether it was Cheney himself, somebody in his office, somebody else in the White House, so they subpoenaed the reporters who had been paying attention to this issue. Miller refused to testify, claiming a First Amendment privilege not to be forced by government to disclose the name or content of information of a confidential informant, provided by a confidential informant. And she appealed the order holding her in contempt when she refused to answer the grand jury's questions. And the case went to the Supreme Court on her petition for certiorari, which the court denied. It was a really high-profile case, seemed to have national implications, and everybody had anticipated that the court needed to clarify at least the extent to which reporters would be able to protect their confidential sources. So it was a disappointing non-decision, a refusal by the court to take the case. The only case that the court has ever decided on this issue was the other one that I worked on, the losing side of, back in 1972. That was Earl Caldwell's case. Earl Caldwell was a reporter for the New York Times, I mentioned him at the very beginning of the course, whose beat was the Black Panther Party, and he was in the Bay Area, stationed in the Bay Area, and covered the Black Panther Party for a couple of years, and then was subpoenaed by the Nixon administration Justice Department to go before a federal grand jury sitting in San Francisco to bring all of his notes, all of his memoranda, whatever information he had accumulated in covering the Black Panthers, and come down to court and testify before the federal grand jury. Well, as you know, all grand juries are conducted in secret, behind closed doors. Public's not allowed. Lawyers are not allowed inside, just the witness or the grand jurors, and the prosecutor who asks the questions. And Earl Caldwell was fearful, rightly so, that if he cooperated with the government's subpoena and went down and testified to the grand jury, that fact would be publicly known, and that would be the end of his reporting career with the Black Panthers, because they would never trust anyone who might go spill beans. And that would upset his unique relationship that he had with the Black Panthers, one based on trust and confidence. And so he refused to testify. He was held in contempt of court for violating the subpoena. And the case worked its way to the United States Supreme Court, which decided in 1972 that reporters do not have a First Amendment right to protect the names or information provided by confidential sources under the First Amendment. And that was the only case that the court's ever decided on that issue. So in 2005, when the court refused to take Judith Miller's case, that sent the clear message that reporters can't honestly promise confidentiality to would-be whistleblowers. So it's, a source with sensitive or embarrassing information about government misconduct can't trust that a reporter won't be subpoenaed to disclose who leaked the information. And then along comes WikiLeaks, following the Judith Miller episode. And WikiLeaks says it provides complete anonymity to leakers. Its website says it does not record any source identifying information, and there are a number of mechanisms in place to protect any documents from being sourced. The WikiLeaks flatly represents that it has never revealed a source. In other words, WikiLeaks can do what the mainstream media can't do: protect confidential sources. Whistleblowers could, of course, go directly to the New York Times if they wanted to, but that would risk their exposure. If the Times were subpoenaed, the Times would have to finger the source under the Caldwell decision. Called Brandsburg, there were other reporters in the Caldwell case. So again, WikiLeaks partially repairs a flaw, a gap in our First Amendment protections for speech and press. If there were a meaningful shield law, that is, a law that protects reporters from forced disclosure of their sources, that reporters and sources could rely on, WikiLeaks might be superfluous. Congress almost passed such a law in the last Congress, the one before the one that finished their work in 2010. The House actually passed a bill that would provide pretty good protection for reporters, and it was pending in the Senate when WikiLeaks released the State Department cables in late 2010, and that disclosure antagonized enough senators to torpedo the chances of enactment of any shield law that year. And then the Congress was through. The 2010 elections elected a bunch of different people who were much less sympathetic, and so the legislation has been stalled, and there is no federal shield law protecting reporters. All of the states, except Wyoming, have, as 49 out of 50, have reporters' shield protections. Some by statute, as we have in California. In fact, it's in the California Constitution. Article 1, Section 2B of the California Constitution protects reporters against compelled disclosure of their confidential sources, or indeed from, quote, any unpublished information. That is, information that a reporter chooses not to put in the story is protected. And in the television context, that includes outtakes, for example. Film that was shot by the television station but not used is protected from compelled disclosure, even though there's nothing confidential about it. So California has a fairly good law protective of the media against forced disclosure of confidential sources and unpublished information. Other states' protections vary. Some come close to California, some are not very good. But the federal government doesn't have any protection. That's why Judith Miller went to jail, and why a lot of reporters who want to cover national security matters or environmental matters or business matters, and they identify somebody within the government who's willing to talk only on condition of anonymity. You got to keep me out of it. You got to promise never to disclose who I am. I could lose my job. I could get hurt. I'm not going to talk to you unless you can promise me confidentially. If you're talking about something federal, there's no protection for the reporter or the source. So, Well, for the reason that Mark identified behind you, because they don't have a presence here that the government could latch onto that gives them jurisdiction to order Assange or WikiLeaks to do anything. I mean, Assange is fearful, has said, that if he is extradited to Sweden, that he's fearful that Sweden will in turn extradite him to the U.S., where he may be prosecuted criminally for violation of the Espionage Act, which is the other big First Amendment issue that WikiLeaks is involved with. The question for us is, could Assange be successfully prosecuted for violation of the Espionage Act, or whether his disclosures through WikiLeaks are protected by the First Amendment. Right after the State Department cables were released, back in January of last year, our Senator Dianne Feinstein wrote an op-ed piece that I put in the Reader in the Wall Street Journal that very aggressively interpreted the Espionage Act, and she demanded criminal prosecution of Assange. And then Senator Joe Lieberman piped up and said that WikiLeaks disclosures are the most serious violation of the Espionage Act in our history, and called Assange a traitor. Not an American citizen, not in America, I don't know if he can be a traitor, but that's what Lieberman called him. Sarah Palin called him an anti-American operative with blood on his hands. Mike Huckabee called for his execution. Senator Lieberman then got busy and tried to put WikiLeaks out of business altogether. He successfully pressured Amazon to stop hosting the WikiLeaks website, and he urged the other companies that supported the WikiLeaks site to terminate their relationship with WikiLeaks. So PayPal and Visa and MasterCard promptly stopped processing donations to WikiLeaks, claiming that it somehow, in ways that none of the companies specified, was not complying with their terms of service. I looked up not long ago the Ku Klux Klan website, racist organization, and they hawk all kinds of paraphernalia on the Klan website, T-shirts and stuff that they sell, and there's Visa and MasterCard right in there cooperating with the Klan, servicing their racist website, but they won't service WikiLeaks site after the pressure from Lieberman. And whatever your view of him as a person, as a senator, his attempts to completely shut down WikiLeaks and prosecute its staff under the Espionage Act doesn't commend him for placement in the pantheon of First Amendment heroes. The Espionage Act itself is a mess. It was enacted in 1917 during World War I at the insistence of President Woodrow Wilson, and it was the first loyalty-type legislation that Congress had enacted since the infamous Sedition Act of 1798. It has a bunch of virtually unintelligible provisions that seem to make it a felony, not just to hand over secret documents to a spy, that's pretty straightforward espionage, but to, quote, communicate information, quote, relating to the national defense. I thought we depended on the press to inform us about information relating to the national defense. Anyway, it's apparently felony to communicate information relating to the national defense to people not entitled to have it if this could, not if it does, but if it could damage the United States or give advantage to a foreign nation. And some of the provisions, there are half a dozen provisions in the Espionage Act, and they're not completely, they're certainly not lucid, and they're not completely consistent. Some of the provisions relate to classified information, some of them just to national security information. Oddly, there doesn't seem to be any law in the Espionage Act or elsewhere that deals specifically with the disclosure of classified State Department communications of the kind that WikiLeaks disclosed. Well, take a look at the Espionage Act and tell me what the constitutional analysis is. Is it consistent with the First Amendment, based on what we've learned so far? We've considered several statutes and asked whether they are compliant with the First Amendment or whether they violate the First Amendment. What are the analytical steps that you go through to judge whether the Espionage Act is constitutional? Anybody? And what's the first thing you ought to look at? Robert? In any way. Well, it looks like it does, doesn't it? Communicates. Communicate sounds like speech, doesn't it? Communicates when a person doesn't have it. So it's speech related. Then the next question is it content neutral? Because if it's content based, then what? Strict scrutiny applies. And if strict scrutiny applies, then what? It's a very high hurdle for the government to jump over. Not necessarily impossible, but extremely difficult for the government to satisfy the requirements of strict scrutiny, which are having to prove that the restriction on speech, they're narrowly tailored to what? A compelling government interest, right, that the restriction is justified by a compelling government interest. Not an important one, not a substantial one, not a pretty good one, not a plausible one, but a compelling one, a compelling government interest. And secondly,